Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland and Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Welcome. It's another podcast of Win with the Law. Learn how to navigate the legal landscape and end up on top with the legal help of the community's most prominent lawyers. My name is Gary Newland, a trial lawyer with the law firm of Newland and Newland LLP. We will discuss issues involving the law and strategies for success so those listening can be empowered to achieve successful outcome when it comes to legal challenges. Without further ado, I would like to introduce Blake Strautins. Blake is the managing partner of Kluever Law and practices in commercial litigation, real estate related litigation, and is an appellate lawyer as well. Welcome, Blake. Tell us how long you've been a lawyer and a little bit about your background.
Well, hey, Gary, first of all, I just want to say, thanks for having me on today. Love what you're doing with the podcast. I think it's fantastic. Pleasure to be here. What do I do? It's a mix of things. A large portion of our client base is mortgage servicing clients, and we do a lot of foreclosure and eviction work for both commercial and residential properties. And then beyond that, we do a lot of mechanics lien litigation, both litigating and defense. For those that aren't familiar with mechanics liens, that's where a contractor performs work on your property and it's enhanced the value, and the contractor doesn't get paid. Either you don't pay them or they don't get paid, and one's going after the other, whether it's the contractor after you as the homeowner or the owner of the property, or vice versa. And the other portion of our practice is really just general commercial litigation, where you've got two companies or two business entities that are arguing over some dispute. And where I come in is I'm trying to solve that problem for them. And if we can do it without court intervention, great. But if sometimes the parties aren't as amenable to an out-of-court resolution as cooler heads would dictate, and that requires the court process, unfortunately, sometimes. And that's where I come in to help, eventually get some kind of resolution for our clients.
Well, that's really interesting. So, a lot of people look at us and they say, oh, we just want to go to court. But the reality is you just want to get the best outcome for your client, and that doesn't necessarily involve going to court. So do you guys use, at your firm, do they use alternative dispute resolution, or is it mostly negotiation?
It's mostly negotiation. In my experience, and every attorney's experience is a little different. I have not found that mediation is that helpful with the types of disputes I've had over the years. But out of court negotiation and just trying to, get people to the table and talking is very effective. And obviously that's contingent on the mindset of the parties on both sides. Sometimes you've got people that are open-minded. They want to talk about a dispute before things get too hot and heavy. Other times you've got people that, they've drawn the line in the sand. They're being stubborn. And this goes for clients and the other side. It's not just the other side. Sometimes it's your clients as well. And they get so stubborn. It's like, no, this is the result I want. And the other side says, I'm not even going to meet you halfway. And that's when you're forced into litigation posture. And unfortunately, I think people really wake up when they get involved in litigation, because it's expensive and it's protracted and it's stressful. And unless you are a routine litigator as a party and you've had experience doing it, it can be a real wake-up call for you.
Now, in Cook County, there's a commercial litigation calendar. Is that right?
That's correct.
So what that means is, for example, law division, when cases are over a certain amount, they get sent to a department where it's usually the same type of judges that hear the cases, and it's the same judges over and over again. Is that fair?
That's correct. Yeah. And when it's below a certain threshold, in Cook County and other counties, typically the matter gets sent to arbitration, and you're going to have an arbitrator that reviews the matter. I believe the thresholds are usually around $50,000. If the dispute's less than $50,000, you're going to an arbitrator, and either you accept or reject the arbitrator's decision. And if you want to accept it, great. If you don't, you reject it. You move on with actual, formal litigation.
Is commercial calendar, do they have a mandatory mediation or arbitration process?
I don't believe so. It's something you can always request, and I often encourage clients that if they really want to get a case resolved, oftentimes the judge overseeing the matter at that particular point in time is more than willing to have a settlement conference where they'll go in with both sides and they'll give it to you straight and tell you the strengths of your case, the weaknesses of your case, and it can be a really useful tool in terms of getting parties to come to Jesus, for lack of a better word, about where their case really lies and how strong or weak it might be.
So what I do, which is personal injury litigation, typically there's always a jury demand, and oddly enough, the jury demand is made by the defense, and people don't understand that. They think the defense doesn't want a jury, but the reality is they prefer a jury. In your situation, are most of the cases decided by judges or jury?
Usually judges. On the plaintiff side, for the type of work we do, you typically don't want it going to a jury. And the reason for that, it's a little different than your practice. It can be a real wild card. And typically you're dealing with complicated issues where it's not really a question of fact on those things. It's more a question of law. And you don't want a jury looking at it from a legal perspective, because the layperson really, they're not that familiar with it. They can get it if you properly educate them. I understand that. But from my perspective, I'd rather the judge be looking at it and from a legal perspective make those determinations.
Yeah, and I've always felt, and this isn't to overly compliment or anything like that. I don't want to sound like I'm being too kind. I'm trying to provide a podcast of where people can learn, but the reality is you're an appellate lawyer too. And as an appellate lawyer, I always felt appellate lawyers were the best on the trial level because they know the law, they know how to use the case law, they know how to influence the judge's opinions. And I think you have an advantage on the commercial calendar over most lawyers because it is about issues of law oftentimes, and you know how to convince the judge through all the various appellate cases and apply them in the best way possible. And so it's always amazing when I have someone like you on my side in a case, because the mastery of the appellate process really does come into play in the trial process, especially I think on the commercial calendar.
Oh, absolutely. I mean, it's for those that don't do appellate work or aren't experienced with appeals, it's a totally different way to look at a case. Once you handle an appeal, you'll never look at litigation the same way again, because an appeal is going back to the 30,000-foot view and looking at everything that happened, good, bad, or ugly. And you're looking at the good things that happened. You're also looking at the bad things that happened. And it helps me as an attorney to represent clients because I find ways to protect them down the road and find ways to, as you mentioned, be more persuasive to the judge, because I've seen a lot of the case law. I've seen a lot of the arguments, and I know what types of procedural and substantive arguments I can make at the circuit court level that can get a claim knocked out because I've litigated it on appeal. And, when you do appeals, you're researching constantly, and you're reading dozens and dozens of opinions. And for most attorneys, it's boring work. I love it personally. You either love appeals or you hate them. My partner, Matt, hates appeals. Won't touch them with a 10-foot pole, but me, I love them. So.
And the judges rely upon the precedent of those appeals to formulate their opinions, which is what really helps you. Now, now that I've totally complimented you, so I have some questions for you, just generically, pretty much on foreclosure. Your firm represents banks in foreclosure. Is that right?
We litigate foreclosures on behalf of lenders and servicers. Yes.
I think there's a perception that somehow attorneys who represent banks are mean, but the reality is you have a job to do. And at the same time, you're hoping the consumer or the homeowner is able to work it out along the way as well. I mean, you're not trying to hurt anybody. You're just trying to do your job. Is that fair?
100%. And I'm glad you brought that up because that is a common misperception that the banks and the lenders and the landlords want to take your home. They want to take your unit, your apartment, your condo, etc. That is literally the last thing they want. They just want you to pay, period. And, I am doing a job for my clients. Do I enjoy the practical reality of having to evict some or foreclose on someone's home and take their home away from them? In no way, shape, or form. My ultimate goal in every case is resolution. If we can find a way to get a individual who's being foreclosed upon to get a loan modification or settle it or walk away with some dignity and decency and make it as painless of a process as possible, that's my goal. I take no joy in if any time you have to foreclose and take a property to a sale and sell it at an auction, that's not a win for anybody, even my clients. That's not a win. A win is when you can resolve it amicably. And if you can get them paying back on the loan, bring it current, some sort of a modification, et cetera, that's a win-win for everyone. And my ultimate goal when I'm looking at at these cases.
Yeah,
And
it's interesting.
Unfortunately, but it's not always a possibility, right? I mean, there are some instances where you just can't afford to make your mortgage payments anymore. You lost your job. You've had horrendous medical debt, whatever the case may be. You had to file for bankruptcy. And again, in those instances, if that's not an option to get you a loan modification or whatever, I'm looking at other ways to exit you from the process in a dignified manner in any way I can.
It's interesting because the banks are set up to make money, and people, because they're giving loans and they expect to be paid on them. And if they're getting paid on them, then you can't foreclose, except in extraordinary situations.
Yeah.
And so I think it's important for everybody to understand that there's a process, and the process is set up in a way in which, there are opportunities to resolve things if in fact the means exist to resolve it amicably. And that's, like you say, that's not always the case. But even then, yeah, it's all about people's dignity. I can remember I used to do evictions years ago when I first started as a lawyer. And I always thought it was important, and I always got more done by treating people with respect. They don't want to be in the situation, and everyone's looking for a way to get out of it where they can move forward as best as possible. And I think it's important to understand that for those people that come into the process, to not necessarily, it doesn't behoove them to be hostile.
No.
The process that only pushes people apart. When firms litigate, like my firm has foreclosure defense division, when we litigate cases and our firms go up against each other,
We do.
It's about what the law says.
I love when you're on the other side because you're reasonable, you're level-headed, you make solid, fact-based, legal-based arguments, and you're really easy to work with. So whenever I see you guys on the other side, I'm actually delighted because I know it's going to be an easy process for me as an attorney.
It doesn't behoove my firm to have you be an antagonist, right? And either way, it doesn't, right? So we want to do what's best for the people, and those people are our clients. In your case, it's a bank, but it's still a client, and everybody's just trying to exit the process. And it's like you also said, a win isn't necessarily what you perceive in other areas. Like for example, in personal injury, a win is getting the client the money they're owed. In a foreclosure scenario, a win could be working out a modification, or a win could be extricating the client from the property as amicably as possible. There's many ways to register a win, and that isn't obtained if people can't talk.
Correct. And look, a win is when you don't have to litigate for both sides. When you're fighting, everybody's losing.
This is true.
Lawyers are winning, but that's about it, not the clients. And so when you can put those differences aside, and focus on resolution as opposed to being antagonistic and fighting and digging your heels in and being as aggressive as possible, the sooner you're going to get to a peaceful resolution.
But if you go to a good lawyer, right, then they're not trying to waste time fighting because they got other cases to work on. So they're trying to do what's best for their client and not milk a file. And that's something else people need to understand. The better the lawyer, it may seem more expensive at first, but in the long run, you probably save money because it's going to be resolved more professionally oftentimes.
Absolutely.
So what advice do you have for young attorneys?
The best advice I can give to young attorneys is, put yourself out there early and often. So in terms of networking and business development, that was something I started later in my career. I didn't understand the importance of it and the importance of getting your own client base and getting your name out there, your personal brand. I probably started when I was about maybe 33, 34 years old. So probably, 6, 7 years too late. Now looking back on it now. And the reason I say that is because, business development, as I'm sure you know, Gary, is very challenging. And the earlier you start, the more practice you get, the more polished you get, the earlier it is in your career that you are building out your network. You're getting to know people. And it's one regret I have as an attorney is that I didn't start that sooner because it's so important.
It's interesting, and I think it is important because it kind of grows on itself too. Each network opportunity leads to another network opportunity, and we can all look back and say, "Geez, early in our practices, I still have that connection. I still, and that's brought me how many different connections." So it is true to start early. What advice do you have for any young attorneys with respect to professionalism and because we've seen it where there's attorneys that represent clients zealously and there's attorneys that are zealots. And how do you see that as well?
It's funny you mentioned that. Earlier on in my career, so I didn't start out doing this. I used to do class actions on the plaintiff side. And I went up against some of the most prestigious law firms in the country. And you want to talk about zealous, and you'll get zealous on the other side of that table. But what I learned was you're not going to make any progress being that kind of an attorney. Don't be a jerk. Don't be an a-hole. You're going to be a much better attorney and much more effective at your job by just being kind, courteous, and treating others the way you want to be treated. I can't tell you how many times I have interacted with other attorneys and they've just left a horrible taste in my mouth because of the way they acted towards me or treated me, particularly when I was younger. And I made a promise that I'm never going to treat anyone that way because that's not how I wanted to be treated. So be civil, be fair, and it will pay dividends down the road because inevitably, in any case you're dealing with, whether it's litigation or contract negotiation, you name it, you're going to need, a favor from the other side for your client. You're going to need an extension of time. You're going to need additional briefing time, et cetera. And your reputation is everything. And you only get one shot at that. And once you hurt your reputation, that never goes away. If someone has a really bad experience with you as an attorney, they'll never forget it. I remember a lot of the really good interactions I've had over the years. What I remember more is the bad ones.
Right.
Forget those. And because it's the legal community of as many attorneys we have in Illinois, it's a small community. You're going to run across the same attorneys over and over again. And because I say your reputation is everything because it really is, because it's a small circle and you're going to see someone that you litigate against 5 years. You might see them 5, 10 years down the road. They're going to remember you good or bad, right?
And the judges have memory as well. I just had a case the other day where the judge was threatening the other attorney with reporting them to the ARDC based on their behavior during the case. And I was thinking, the judge didn't end up reporting him, and none of the attorneys did, but we all had a bad taste in our mouth with respect to the attorney. But I can only imagine when he has a motion that can go either way in front of that judge next. what's going to be going on in the back of the judge's mind. He's, his reputation's tarnished. It's definitely not going to help his client, and he didn't do a service to anybody nor himself.
No, and judges remember that. I've been in court and I've seen other attorneys be too zealous in front of a judge. And even to the point where the judge has told them, the next time you open your mouth, I'm going to have the sheriffs hold you in contempt and escort you out of here. It's like, you probably shouldn't have even gotten close to that, much less at that point.
I saw the funniest thing. It was one of my cases. It was one of those times the judge was ruling in his favor. It was evident against us. And he kept on talking. And he just kept on talking. And the judge said, "You just talked me out of ruling in your favor." And then he ruled against him because he said something totally silly. And the reality is, you got to know when to stop, right? And that's
to shut up. Yeah.
It was so funny, and then you try not to laugh at him, but it's kind of hard not to chuckle. And but basically, yeah, I agree with you. I think that the most important thing for the young lawyers is, networking and being professional at all times. They have to understand early on that you don't get points for acting rude or unprofessional at any time. It just never benefits anybody.
Yeah, I couldn't agree more.
How has technology impacted your practice?
Substantially. From when I first started practicing, and I've been practicing for going on, God, I've lost track. It's been so many years, 16 years, I think, almost now. And I'm young enough that I'm only 42 years old, but old enough to remember operating a fax machine. So technology's come a long way since then. I remember having to send faxes when I was a law clerk and putting in 30 phone numbers in a row and sending out a 3-page letter to that many people. But you look at case management systems, you look at the ability to generate templates on documents, the ease of research in case law. I again, old enough that I remember looking at a book in law school to do legal research before, without using Westlaw or Lexis, et cetera. And the ease and at which you can do legal research now, and the knowledge you have at your fingertips is incredible. And things just keep progressing. Now we've got AI becoming a more widely used tool. I'm still trying to figure out ways to work it into the practice of law, because there are a lot of pitfalls, or there's a lot of mines you could possibly step on. From the firm management perspective, I use it to help generate employee reviews. It's fantastic for that. You put in what attributes you want to talk about with the employee, what they're good at, what they need to improve on, and you can get a fantastic review generated out of ChatGPT in no time. But where I really want to figure out how to use it is in the drafting of pleadings and legal documents, to the point where it's really benefiting us and helping us be more efficient for our clients and more efficient with our time. It's I think the possibilities are endless, and I'm excited to find out how exactly we can implement it into the practice of law. But being mindful of the fact you have to do it ethically, and that both goes for the courts, your clients, etc. There's still a lot of open questions, I think, and I'm curious, what's your view on that in terms of the use of AI these days?
That's a great question. I've decided just within the past weeks to go all in with AI. I feel it's the only way I can compete against. We're competing against insurance companies that have endless resources. So it helps me add additional parties to my team. I have artificial intelligence on my team now. So we use Clio as an operating system, and that has an AI component that we're utilizing. And then I was looking at recently the LexisNexis AI, and I did a free week of it. And you were talking about being a law clerk. It ultimately replaces the law clerk.
Yeah.
And you have to, just like a law clerk, you would have to review everything it does, make sure the law clerk gives you the right cites, and did everything just so. You have to do that with the AI as well. But it's the time that it gets it done. Something that I would give a law clerk an assignment to do that would take a week and many, many hours is now done in 5 minutes.
Yeah. It's astonishing. And in connection with that, we talk about how technology has changed, the practice. This is not my office downtown. This is my home office. I'm a big comic book fan, as you can probably tell from the background there. But our firm is almost 100% remote. We've got 36 employees. Some of them are throughout the country in different states, and we embrace. When COVID hit, we embraced the remote work immediately. And we are probably one of the few firms that has held on to it because it's been so successful for us. And our employees love it. They love the remote aspect. They love not having to commute to the office. I personally love not having to commute to the office. I think it's great. And I'm more efficient because of it. And you look at the ways, I mean, look at us here on video talking to each other. As recently as a few years ago, this wouldn't be as commonplace as it is now. And now
Right.
you can have these meetings, anytime with people from all across the country, and it's become so widespread and readily used and available. It's just fantastic. You think about depositions. Depositions, you used to have to travel across the country if someone was located in California or something like that. There was no remote deposition option other than
Yeah.
over the phone. You were going and taking the deposition and flying home. And now you can do it on Zoom. It's fantastic. And you look at court, the ease of which we can appear in court, and I look at that as a win for everybody. Not just us, but the clients, and for individuals who can't afford attorneys. Think about how expensive it is for an individual that doesn't have an attorney to have to go down to downtown Chicago, Cook County,
Right.
6th and Cal, whatever, and participate in a court hearing for 3 minutes and then have to take an entire day off of work. Now they can spend literally 10, 15 minutes out of their day on a lunch break or smoke break, whatever, from work, and be a part of the judicial process without seriously impacting their lives in a negative fashion. I think the way it's expanded access to justice has been a really fantastic addition to the legal profession as a whole.
I couldn't agree more. I think you put it very well. Let me ask you, what do you find most rewarding about what you do?
Honestly, the most rewarding aspect is helping people. For me, there is no greater satisfaction than helping a client solve a problem and hearing them say, "Thank you so much. You have no idea how much this means to me. It was stressful. It was a horrible situation, but you got me a great result." I mean, that's why I do it. There's no other reason. I mean, I enjoy practicing law, but nothing can replace the joy I get from helping people solve problems. I think it's remarkable.
What's interesting today, I had one of those situations where, and I'm sure you have these too, where there's not much you can do. That the client's kind of screwed, and I found that, that happens from time to time. We're lawyers, we find back doors, trap doors, whatever we can do to get them in a better situation. But sometimes there's just not a good end. It's just somebody's got to lose. And basically, I talked with them and I said, you know what, we're going to do our best for you and try and navigate you through this with as little damage as possible. But no matter what, you're not going to be where you want to be. And I went through it with them and explained to them why. And sometimes the system it's merely an attempt at justice. It's not justice, right?
Yeah.
And it felt good because I connected with them and they understood. Even though I couldn't, you always love that. Hey, we worked it through. We won. Everything worked out better than we thought, right? But that's not always the case. And but it was still rewarding to let them know that we were going to be there for them, and we were going to do the best we could, even in light of the fact that it's just not going to be a happy ending.
Those are some of the toughest cases, though, because I personally connect with a lot of my clients on a lot of their cases, and when they don't win, when they don't get the outcome that they want or that's desired, it's not just that. I carry the burden too, because I feel you second question yourself. Was there more I could have done? Was there a different approach I could have taken? Was there something else that I could have done differently to get a better result? And it's a personal thing that, I don't share it with the clients, but I hold it in personally. I'm keeping it inside, but it's
Yeah.
not easy. You work on cases, and these are everyone. There's people. You're working with people on a daily basis. Our clients, they might be corporations, but you're dealing with people, and you have that human connection. And it's challenging and struggling when you don't get the win. I love to win. Let's be honest, every attorney loves to win. If you're a litigator, you love to win. And when you lose, it hurts, because you're thinking, man, what could I have done differently? What could I have changed to get a different outcome? And sometimes there's no answer, as you mentioned. Sometimes you just did the best you could. There was no good option for the client. There was no good result. It was just, what's the least bad result, right?
Yeah. And then, and thank God that's not most of the time, but it's enough of the time. Well, I really thank you for being here. It was great having you. Will you come back sometime?
Absolutely. No, I'd love to. It's been wonderful chatting with you. I've enjoyed it. Maybe I can interview you next time.
That'd be great. Do you want to be the host on my show, or do you have your own show?
I don't have my own show.
Okay.
I've never gotten into the podcast game. I applaud you for doing this. I don't know if I've got the questioning skills that you have to make it as successful as it is. I can certainly try.
You're a natural. So I think, that would be fun. Maybe I'll be the guest on the show. That'd be fun. But
have you ever been a guest on your show, or are you always just asking the questions?
Not yet. I haven't done it yet. I've done the partners, but I'm thinking I'm going to have to go that route a few times here.
You should.
It's fun because my daughter TikToks these too, so you might be on TikTok at one point here.
I will probably never see it because I've never been on TikTok.
Well, you'll hear from
one platform where I refuse to engage.
You'll be at a wedding and someone will say, "I saw that guy on TikTok." So, well, I appreciate it. And this is Win with the Law signing off. Till next week.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.